Hi, welcome to the Recent Developments panel. I am Bill Ford, and I will play the moderator and the pretend game developer for this discussion. So what we're going to do for this discussion, in order to try to bring out some of the recent developments, is work through an extended hypothetical, where I'm a game developer going to my team of advisors here for thoughts on what to do about my proposed game. Now, my proposed game is supposed to address the age-old question, where is the Citizen Kane of video games? And I want to answer that question, sort of, with my proposed game. So what is my proposed game? Well, what I want to do is take an existing game that exists in the physical world. It's a physical card game that comes in a little cute pouch like this, called Love Letter. And the object in Love Letter is to get love letters to a princess. Well, what I'm going to do is retheme it, and I'm going to get the scripts for the Citizen Kane of video games to Orson Welles. Now, the way this game works is very simple. The 30-second explanation is that there are only 16 cards in the game, and on those 16 cards there are 8 different characters, each with a different numerical value, and each with different effects on the game. Every player is dealt one card. On your turn, draw one card, play one card. At the end of the round, which doesn't take long, whoever's left, still playing, and who has the highest value card gets a point, and you play to a certain number of predetermined points. The highest value card is, of course, the princess in the game, since the objective is to get the love letter to her. So this particular game has already been rethemed officially multiple times, and unofficially probably dozens of times. So I think it will work well for my retheming, where I take the physical card game and I turn it into a video game, say an iPad app. So it'll be an electronic implementation of this physical card game using the exact same game mechanics that exist in the game. I'm not changing any of the game mechanics. It will play exactly the same way with the same number of cards. But of course, I'm going to change the theme of the game so the princess will become Orson Welles. Now, this is just a rough idea of what the card would look like. All the artwork would change so that it won't bear any resemblance to the original card. I'll even rewrite the text that specifies the ability of the different characters in the game. But again, each character will have the same effect on gameplay as the original game. Now, card number 8 is Orson Welles. As you can tell from the handout that's going around, you can see the different cards that I propose to use. Several of them will be characters played by Orson Welles. So there's a card for the priest in the original Love Letter game. That will become Cardinal Wolsey, a character played by Orson Welles in A Man for All Seasons. Several of the other cards will be characters played by Orson Welles in various films. There's also a living actress on one of the cards, Claire Danes, who appeared in the film Me and Orson Welles. So I want her to be on one of the cards. And then I want to replace, as the handout shows, the card for the guard will become RKO Radio Pictures, using the logo for RKO Radio Pictures. So I want to sell this game, and I want to have in-game advertising as a source of revenue. But what I want to know is, what are the legal issues that I might need to worry about in producing this game? What is it I might need to license? And if so, if I do need to license something, how do I go about it? So what are the issues to think about? Well, let's start with patents. So I'm adapting a game in its entirety, but retheming it. There's no science involved here. This isn't a pharmaceutical. What relevance could patent law possibly have to my particular game? I don't know if there is a patent on Love Letter. I don't know if there could be a patent on Love Letter. But is patent law something that I need to worry about? And if so, what is it that I need to worry about? And I'll start on this question with Ross. Although we're going to take a fairly freewheeling approach to this discussion, there's a handout with a list of authorities that we thought were likely to come up. And so if you hear something about a case that you think is interesting, the citation will be on that case. The discussion won't necessarily be limited to things only on that handout, but we tried to hit the things that we thought were likely to come up. So patent law, is there any reason to be concerned?
Well, there's a couple assumptions we have to make based on the hypothetical. First of all, patents protect innovations. They protect inventions. They protect functional things. That includes video games. That includes methods of operation. Playing a card game is a method of operation. So in theory, it is protectable subject matter for patents if you prove that your method of operation is new, useful, and non-obvious. However, because we are reskinning a pre-existing game, and I'm assuming the pre-existing game has been out for years, right?
Several years.
Love Letter has been out for years. There is a limitation on time periods during which you can seek patent protection, right? So the patent system, actually, quick question, by show of hands, how many people in here have ever taken a patent law course? Okay, how many people have never taken a patent law course? Okay. So So let's back up a step.
So he can say whatever he wants.
Let's back up a step. A patent is, the province of the federal government. It's a grant of some limited set of rights if you invent something, right? So if you build a better mousetrap, if you build a better chair, if you build a better something that has function, you can apply for a patent at the United States Patent and Trademark Office by coming to an attorney such as myself to represent you before them. And you will argue back and forth with them over a period of anywhere from 1 to 3 or more years about why your invention is great and why you deserve a patent for it. And at the end of the day, if you win, you'll get something that looks sort of like this, which is a United States patent. This one happens to be for a sanity system in a video game. So the makers in that, as an example of what you can get, they developed a system, this one is for Nintendo, where your character in-game starts to go insane in response to things that happen in the game, whether they get startled, whether there's a ghost that pops out or something. And as your character goes more insane, the game becomes less responsive to user input to control that character. And not until the character's sanity level goes back up or insanity level goes down can you effectively control the character again. They have a patent for that. Another example that we have is a Microsoft patent. Has anyone ever played the game Midtown Madness? It's an old Xbox game. There is a feature in that game called Hunter Game Mode, which was one of the early versions of a zombie game mode in multiplayer, where you start out on one person's the zombie, everyone else is fine, and the zombie, when they tag someone, they turn them into a zombie, and the last person standing as not a zombie wins or gets the most points. So they patented an adaptation of that sort of game of tag, as you mentioned earlier, that for automobile games in Midtown Madness. It's a somewhat narrowly crafted patent, but that's also an example of something you can patent. We've developed we've obtained patents for clients on everything from using special mouse controls. If you invent a better user interface, for a game, if you invent better software that does something under the hood of your video game. We recently obtained a patent for a company called Techland. They have a new game out called Dying Light. A week and a half ago, we finally received their patent from the patent office for some of the technology under the hood in Dying Light that allows them to have the character moving around in a virtual world. Dying Light's a zombie game where it's a first-person view and you're running around the world. But it's a method of determining how the user can jump around, how the player character, rather, can move around in the world in real time without having pre-designated paths. So it makes it much more free flow throughout the virtual world, and we have a patent for aspects of that. So all of this is my purpose here is that there's lots of aspects of video games that can be patented and that are being patented. So with respect to our card game, Love Letter, or our adaptation to Orson Welles, my first question would be, well, there are companies out there, for example, Wizards of the Coast, that also have card games. And are they patenting their card games? I don't know, maybe you are shocked to learn this, but I was not shocked to learn that, yes, they're getting patents on implementations of card games for their Magic the Gathering franchise. They're currently in a litigation against Cryptozoic.
I knew I should have put that case on the list. Cryptozoic is not on the list.
Wizards of the Coast, but it's not. There's no opinion. It's a pending litigation. Wizards of the Coast is suing Cryptozoic. Cryptozoic came out with a game called Hex: Shards of Fate that Wizards of the Coast believes is little more than a reskinning of Magic the Gathering. Now, I'm not going to comment on the merits of the case because we represent a third party in that case that's become involved. But there's the subject of debate is whether or not, and I'll let the copyright folks speak to this down the road, whether or not they reskinned it enough. But there's also a patent infringement allegation in the complaint over one of the patents that Wizards of the Coast holds on how you and when you flip cards. You know, the order that you play these card games and the methods of operation that go behind it. So in looking at Love Letter, I would want to do, if you came to me and said, what do I need to worry about patents? I would say, well, we need to find out what's the universe of patents that people hold on card games mechanics such as this. It's not a hard search to do. We have professional vendors that we hire to do it in very short order and very inexpensively, but you would want to get clearance for that. I would also ask you if you developed anything new in your method of operation of playing this game. I think in this situation the answer really is no. There's no new methodology to it. But if there had been, one thing to keep in mind as you develop functionality for your own games is in the United States, at least, you have a grace period of about 1 year in which to file a patent application to protect your invention. If you have publicly disclosed or used your invention more than a year ago, you have just thrown your patent rights out the window and dedicated the functionality of your game to public use. Most foreign countries in the world have an absolute novelty requirement that says any public use or disclosure it destroys your patent rights immediately. You have to have absolute novelty in order to seek patent protection. You can rely on your first U.S. filing date to pursue patents in other countries if you do it within a certain time frame. But again, you still have to have absolute novelty when you file your U.S. case in order to have that option. So those are some of the things I would say. Last point I'll mention is design patents come into play with video games quite a bit. We do a lot of design patent work for video game companies. Microsoft in particular, we've done design patents on, well, the Xbox hardware, the box itself, the controllers, the accessories, but also the on-screen skins, the on-screen avatars, the on-screen designs. You can get design patents for on-screen depictions of user interfaces. So, you know, do we want to adapt this game for in a video game environment? Do we want to adapt it electronically, or are we creating, you know, a physical version of the game? Because if you're going to adapt it electronically to a computer-based game, then we could also look at design patents for the user interface you design around your reskinning of the game. Whereas if you left it as a physical card game, then copyright would be generally considered the avenue of protection. I think I've rambled on enough there. Any specific questions?
Well, one follow-up question. I hear there's this case called Alice, the Supreme Court decided. Does that change the landscape for the granting of patents for gameplay mechanics?
It has, and it's interesting because, so for those not familiar with the case, it's Alice v. CLS Bank. It was decided last summer, and it is a sea change, really, in the way that the courts are viewing patentable subject matter. And in the Alice case, there was a patent at issue for a method of hedging investment risk. And the court ultimately said, look, this is just an abstract idea that, you know, all you're doing is you've taken this notion that if two people place orders, you make sure that they, you know, both can close the transaction before you finalize the deal, and you're doing it on a computer. That's just an abstract idea and saying apply it. So Alice is sort of the, you know, in the patent world, we sort of think of patentable subject matter, it kind of moves back and forth with a pendulum. Back in 1998, there was a case called State Street Bank that a lot of people are probably familiar with, and that's a case where one of the courts said that business methods are patentable, that they are patentable subject matter. That was sort of when we're full pendulum swing to patent holders' rights, to the broad protection of subject matter. After that, the floodgates opened on people applying for business method patents at the patent office, and before you know it, we have patents for reserving a restroom on an airplane. We have patents for exercising a cat. We have with a laser beam. We have patents for how to swing a golf club. I mean, all these patents that there was really poor quality control at the patent office for a long time. And as a result of the State Street Bank case, it gave people a lot of fodder to argue that anything should be patentable. And then patent trolls started coming up, and now they're enforcing these bad patents. And that's what really brought the problem to the forefront, that these non-practicing entities are enforcing patents that a lot of people think never should have been granted in the first place. And now Alice was sort of we've come full swing, and now we're mid-pendulum swing with the Alice case back against patent holder rights and against, not patent holder rights, but against patentable subject matter. And we're really narrowing the subject matters that can be patented. So Alice basically says, if you are trying to protect an abstract idea and all you're doing is saying apply it or do it on a computer without adding a substantial amount more than that, then you're not going to get a patent for that. And the examples that I mentioned, the patents that I mentioned, the Microsoft one for the Hunter game mode, that was granted at a period of time when we were full, right after, it was after State Street Bank. There were very broad notions of patentable subject matter, and that patent was granted. I strongly question whether that patent would be granted today. I think that the Patent Office is taking a much stronger approach to patentable subject matter. They're issuing many more rejections in view of the Alice case. And so what applicants are doing is they're including much more detail about their algorithm in their claims of the patent, which define the boundaries of their invention. So before they would just they would list the sort of almost a pseudocode algorithm, but at a very high level for something, and they would put it in a claim to a patent and they would get it. Now that's not going to happen. You're going to have to go another level deeper into the algorithm, and if your algorithm, you're going to have to show that your algorithm somehow works better than another algorithm for doing the same thing before you're really going to get the patent for that. And the Techland patent is an example of that, where this patent was issued after the Alice case was decided. This patent actually did receive a rejection during prosecution of the application in view of the Alice case, and we had to come back and argue with the Patent Office why this patent should still be granted in view of Alice, and then we ultimately got the patent granted. So yes, Alice has significantly narrowed the level, or I should say it's not significantly narrowed, but it has narrowed the subject matter that you can protect with patents. You can still protect things as long as you show that you do it better, you do it faster, or something that it has some sort of technical interrelationship to something else. It's going to become more difficult now to get patents on pure gameplay than it used to be.
The one you just mentioned, that's the first one on the list, the 652 patent, correct?
Yeah, that's the 652 patent, is the Techland patent.
Let me ask a policy question for anyone who wants to weigh in. Is it a good idea that the Patent Office is granting patents for gameplay mechanics? The arguments against doing it, I suppose, would be, one, the Patent Office may lack expertise in this area and do nothing to cultivate expertise. Maybe we don't even want them to. Two, do we really need the patent system as an incentive for the creation of gameplay mechanics? The R&D cost of a gameplay mechanic is not exactly similar to a new drug. So should we be worried the Patent Office probably can't do a good job with this and maybe doesn't need to?
Yeah, I mean, I work in trademarks mostly, but even with those, they can't differentiate a different genre of game, let alone such fine-tuned mechanics like an insanity meter. So when you're talking about policy-wise with patents with games, I mean, patents by nature halt innovation from other companies on that subject matter, basically. And in games where now anyone can go in their garage or their bedroom and make an app or make the next, fill in the blank whatever success, if now they have to also worry about this endless slew of patents coming out that are stopping entire genres of gameplay or entire modes of gameplay, that's just not good for the industry. So, policy-wise, I'm certainly, I wish there was a little less work for us, I guess.
I'm a registered patent attorney, though I do not do it full time. Ross has a tougher job than me, and I do transactional IP now. But I think so too. I think mechanics are adequately protectable through the copyright system as part of the gestalt of essentially how you fix the expression of the idea in a medium. So I think copyright pretty much covers mechanics.
I have a follow-up question for you on that point then. Because copyright carves out protecting functionality.
Right.
So how do you then use copyright to protect an underlying game mechanic that's functional in nature?
All right, let me just pause real quick for the benefit of everyone who might not have taken copyright. All right, so we've just moved on to copyright. This is the relevant statute that we're now talking about, 17 U.S.C. 102B. Now, the A that's dulled a little bit here is what is in copyright. The B section is what's out, what's not protectable through copyright. So the question is, aren't game mechanics in the 102B category and therefore not eligible for copyright protection? And if that's the case and we don't think the Patent Office should be doing it, well then, do we have a problem? But the question to you is, what do we do about 102B and the idea of protecting a gameplay method process system?
Right. Well, first, thank you for that restatement, because it gives me some time to think about your very hard question, which is what he always does. I have two ideas. The first is I was considering on a policy basis and not a functional basis, a should rather than an is, and everything he stated is absolutely true. But and from the policy basis, it really goes back to what the moderator was saying, that the development cost of a mechanic is substantially different than the development cost of what I think patents were intended to do, which were essentially inventions in science and technology. And as far as the is concerned, you're right, there's a hole there, period. There's a hole there. But I think it's very difficult to think of a mechanic, and maybe your new patent, the 625 or 652 is one example, but it's hard to think of a mechanic that doesn't come forth in some way with an expression, or as part of an expression, a fixed expression.
Let me just clarify something. Let's get to a nomenclature issue. When we're talking about a gameplay mechanic, to me that means the almost the genre or model of the game. Like all these games now that you run down one of three paths and you have to switch back and forth between one of the three paths. To me, that's a gameplay mechanic. What's under the hood in the Techland case of, responsive to receiving user input, doing some analysis and figuring out where a character actually can move or grasp onto or jump, has absolutely nothing to do with the ultimate goal of the game. To me, a gameplay mechanic is what's the goal or the objective? Is that what we're talking about here?
Yeah, I think what we mean here is the underlying rules. Now, rules can be written out. We use the word rules in two different ways, right? So you buy a game, it comes with a manual or a rule book. That's one way of using the term rules. But those represent an underlying system for the game. Yeah. And the term mechanics is what is often used to describe those underlying rules.
I think everyone. I hear what you guys are saying, and I agree with you in principle. Fortunately, the Patent Office is actually already taking that position in view of Alice, of the Alice case. I have not looked at every single patent the Patent Office has issued since Alice, but as far as I'm aware, there's no patents that I think we would all consider to be directed to a gameplay rules since the Alice case issue.
Here's the other thing that comes up, and it's a practical issue. A lot of the people in this room are developers or law students. Most applications, particularly non-AAA applications, have budgets of less than $200,000. A lot of them have budgets of less than $50,000. And patents have a strict liability violative standard. I mean, that's just the law. And copyright, there are knowledge or implicit knowledge elements. And I was shocked to see that we're coming up on 9 million patents now.
Oh, we passed it, actually. Just got a notice of allowance for 9 million.
Right. So we've got, there are 9 million patents. I always say, and my learned colleague can correct me if I'm wrong, there are roughly 4 million in force at all times. You know, and I have found them to be, in my career as an attorney, relatively unsearchable, and those searches to be relatively unreliable compared to, say, a trademark search. And that's not because patent attorneys are nefarious, it's just because it's difficult. It's very difficult. On average, they have 20 claims. On average, each claim has 100 or more words. And then there's interpretive elements that there is, in fact, an entire hearing for in the law. So it's, and people don't know which way those hearings are going to go. And they often settle the cases after that. So even doing a search and then having a very sharp person like somebody on this panel interpret the patent claims is not really enough to clear it. So those things all factor into my thinking about why I would like it to apply less.
And that's also a generous budget per game now. A lot of studios that are even very successful might make millions a year, but they farm out games instead of making one big product anymore. So when they're farming out those smaller games, each game might have a budget of $5,000, and they're not going to do a patent search with that. They're not going to do, they barely do a trademark search. So it's policy, and that's becoming, for good or for bad, a lot of the norm of certainly the App Store or on Steam, things like Greenlight. It's very much quantity over quality now, and legally and policy speaking, there is absolutely no regard paid to patents, which is, I think the policy is kind of catching up with, which is shocking with how it usually moves. But
well, and the very last thing, the Wizards of the Coast and EA and Activision, there's definitely always going to be a place, but on a policy level, I contemplate the balance, because those guys already have a large enough hammer, in my view. But I'm thinking about it out loud more than I'm taking a position. I'm looking at you quizzically.
I'm not trying to argue that. I actually think it's interesting because I guess philosophically we need to ask ourselves the question of, the first person that developed the genre of games of the 3 tracks that you're running down, moving back and forth. I mean, the first one I remember is, I don't know, is based in like subways or trains, and I don't know if there was one before that, but should that person be upset when someone copies that model and reskins it to Looney Tunes Madness or Invincible Me?
And I have a favorite I want to ask you about. My favorite, and we didn't talk about it, and I feel so bad because you tried really hard to say, hey, what patents are relevant for the handout? Now we're going to talk about all these patents that are not on the handout. Drop in, drop out multiplayer. Remember from Gauntlet back in the day? And Ross runs a really nice blog that has gotten darn near all the video game patents. We won't say that, but you got a whole bunch of great ones analyzed. And what's that?
Patentarcade.com.
Yeah.
So if anyone follows that, that's me.
I know you've got that. I mean, I know you've talked about the drop in, drop out multiplayer, and that's become that. I don't know. That's a necessity these days, right?
Well, yeah. I mean, another example I like to use is, imagine if back in the days of Doom and Wolfenstein 3D, I think Doom, one of those was the first that you had mouse look, with a mouse to look around in a 3D world, and circle strafing someone in multiplayer where you hold down the control key and use your mouse to go around them in a circle while still pointing your gun to the inside of the circle the whole time, and you could just circle around them and kill them easily. There were no patents on those user interface mechanics either. So imagine if John Carmack or id Software had a patent on circle strafing or mouse look, and if he even got a penny a game. So there's lots of things like that you could pursue that work.
But then Wolfenstein would have never been made, and do you want to live in that world? What do you think, Patrick?
I think a lot of these things get caught up in the copyright infringement claims, right?
Right.
And as Greg was saying, the waters get muddied in the way they allege those claims now, and we're seeing a ton of those cases in the mobile world, right? Mobile clones, it's everywhere. Everybody's saying, no, you can't do a Clash of Clans. It looks too much like my Clash of Clans, which was a clone of something else, right? So I think there are certainly tying the creative elements in with mechanics in those cases, regardless of whether there's a patent claim or not. And I would worry from a policy perspective that if you add the patent protections in as well, that we're just going to stifle a lot of the creativity of what's going on in games, which is inherently iterative and creative and riffing off of somebody else's, right? So that would be my concern from a policy perspective.
Yeah, and the game industry can't become the music industry. This cloning and reskinning policy in the actual developer side of things is going to happen. There's always, whether they have to move to browser-based or find another distribution platform, it's going to occur. This is how people make games now. They are inspired by something, they put their own spin on it, and they make it. Whether that's, still a derivative work or truly a transformative work, who knows. But industry-wise, it is happening. That is reality now, and saying we're going to make policy or laws to fix that when, Apple's not even playing ball when you send proper takedown notices and things like that. It's like saying, we're going to shut down Napster and that's it. We defeated illegal music. All the record labels are going to be billionaires again. It's just the AAA studios need to kind of legally be willing to play ball and change some of their enforcement habits here, or the little guy's going to take them over within 15 years. Angry Birds exploding, and then the next one that explodes, and so on and so on and so on. That's replacing people lining up to buy the next Madden, because the AAA studios, for very obvious reasons, have gotten lazy. Call of Duty's the same game every year. Madden's the same game every year. But it still completely shatters sales records for now. When other distribution platforms become easier and more accessible and everyone's on them, that's what's going to start completely replacing that. People play games on PC now, not console, in a younger generation. And the console industry is dying, and with it are these older protect the genre policies, I think.
When you said PC, you mean mobile?
No, I mean PC.
Just like 1994? What
Yeah,
are you talking about, man?
I think Steam is going to be on top of Apple for the first... I don't know. That's a good question. We'll see.
Okay, everyone write down. Ryan Morrison said PC games
That's
are
right.
dominant.
Because look at esports. Competitive gaming and Twitch and things like that are replacing sitting down and watching a football. I mean, I'm still, unfortunately, a very sad Jets fan. But, football is 5-year-olds that, my friends have children. They don't watch sports. They watch Twitch. They watch competitive gaming. That's all played on a computer. They're not playing that on mobile devices. So to be their stars, they go on their computer and they download Dota or they download League of Legends. Hearthstone's coming to mobile, so maybe you're right, and I'll be completely wrong and eating my words in a couple of years. But with the millions of dollars in prizes in esports, I think that's enough to keep the PC market for now.
As a bit of a sum up on this issue, it is the case that the black letter legal rule is that game mechanic is not copyrightable. And you can see that rule reflected in something like the Copyright Office's Form Letter 108. You can see that rule stated in a case like Tetris that's on the list. But as people here on the panel pointed out, courts have found ways to protect game mechanics indirectly by linking it up to the visual display or something else. So, for example, one of the cases on the list, Da Vinci Editress versus Eco Games, involves the reskinning of this game called Bang. And it was reskinned as this game, Legends of the Three Kingdoms. There are more cards in this than Love Letter, but the cards are fairly simple in having characters with simple effects on the game. The court in that case said that maybe the character cards in here qualify as literary characters that are subject to copyright protection, and if you just copy their abilities, even though all the artwork's changed, and it's a totally new setting in this game that takes place in ancient China, that might be copyright infringement. A reasonable fact finder could find infringement there. I think the opinion is somewhat incoherent on some of these points, but it's consistent with some of the other cases. To pick an older one, I brought a prop, so I have to have an excuse to use it. So if you plug this device into a Galaxian circuit board, well, not this specific one, Doc tried, and the pins are a little bent, so we couldn't get it to fit in. But if the pins are straightened up and you pull out the board that's similar in size to this from the Galaxian circuit board and plug this in, this will speed up the game. Now, as best I can tell from reading the opinions, the chips on here don't contain any of the artwork used in Galaxian. All it does is speed up a process. And you might think, well, this is probably beyond the infringement analysis then, because it speeds up something unprotectable about Galaxian, that's the process, and yet the court said that it was an infringing derivative work. In other cases, I think look like this, where courts have found way to hook onto either the display or the character, and in effect protect the process of the game. You can also see that, I think, in the Breakout and Tetris cases, where there isn't much more to those games other than a process. There is some optional possibilities of background music that's clearly protectable and background artwork that's clearly protectable. But as far as the basic gameplay of Breakout and Tetris, it's arguably all process. And yet a remake of Tetris, the court said, is infringing. You'd need to change the block sizes. You'd need to change the way they move. Well, it sounds like you're changing the process, and it sounds like you're changing the mechanics, but that's what the courts have said. So,
at the very least, it becomes almost an evidentiary issue, right? I mean, it's something that paints a bad picture of the actual copyright infringement. So they combine it all together, and it makes it look worse. I mean, that's what they did in the Cryptozoic and the Wizards complaint. If you read that, which in full disclosure, I actually represent Cryptozoic, so I can't really talk about that case in particular. But I would tell you to go read that complaint. It's an interesting read. But yeah, you tie it all in together, and I believe the patented issue in that one, Ross, I think it was about to expire, or already has expired.
It expired before the game launched.
Yeah,
but they're still asserting the claim in the case.
I think they're how. So
it was after a Kickstarter, right?
Yeah, they're asserting it based on testing and beta.
Yeah,
actually, I think it was it's a weird claim.
Yeah. All right, well, let's move on to something else. I've got these images I want to use in the game that I pulled from movies. Should I worry here? Can I maybe claim fair use to take a still image from Citizen Kane, The Third Man, me and Orson Welles, Casino Royale, and A Man for All Seasons? Or am I going to need to seek a license for this?
Yes. Okay. But have it.
Next question.
But okay. Before you get in trouble, 5 things have to happen. Okay. 1, you have to be doing something wrong. You're doing something wrong. Okay. 2, the other side has to know about it. If you're making an application, mobile or social game, odds are it will fail horrifically. So you may never reach 2. Go use your unlicensed Orson Welles. Okay. 3, they have to be pissed off. Sometimes people see these things and they're not pissed off. Sometimes Orson Welles' estate's got better things to do. Okay. Now, and again, I'm not talking about the law here. I'm talking about what happens outside the store every day. And then 4, they have to be really pissed off. What's the difference between 3 and 4? About $600 an hour. Okay. Now, start letter writing, start a complaint. And then the 5th thing is you have to not be able to extract yourself through a settlement or other mechanism before you really get slapped on the hand. So if a small developer was coming to me with no real history of success and a low budget, I would talk to them about those 5 things, and I would talk to them about where they're most likely to get a claim, maybe Living Actress, newer films, and then I'd try to talk to them about budget, and I'd also talk to them about the horror of working with a movie studio. They can get a 5-figure request to the extent they can get an answer. That answer might come back with a 5-figure licensing fee for a still from a film. So it's going to be tough.
With approval rights.
Oh yeah, with approval rights for someone that is never played a video game before and has no understanding of what exactly you're trying to do. So I mean,
marketing commitment and. Yeah.
Oh, that's right. Marketing commitment. Don't forget minimum guarantees. Yeah, I mean, just all kinds of comedy. And you represent a few movie studios, so you're not pretending to know. But one last thing I'll say, and I know some video game developers are mathematically inclined and others are not. But the 5 things, in a math sense, are all ands. So the odds of flipping a coin 1 time and having it be heads is 1/2. The odds of flipping a coin 2 times and having it be heads is 1/4. Okay? So the odds of each one of these things happening are usually a lot less than 1/2. They're all multiplicative. By the time you get to 5, it's usually freakishly low. So a lot of the small developers, and I don't mean take 2, I do tell them to take some risk. Maybe these risks are a little too high. But if you want to do a character whose name was a solid misspelling of Orson Welles, who looked a little bit like him but maybe had red hair, I'd probably say I think that's relatively safe.
What about my desire to license from multiple movie studios?
Well, I mean, just before we even go to that, I mean, that's just a no, really. I mean, really, that's, even if it's a bigger studio, it's just not worth it then. But, so I'm certainly the mere man among three giants here. These are three of the greatest game attorneys in the world, and I am some young-blooded idiot. But that also means I work with a lot of the smaller developers. I work with mid-level studios instead of the giants. And all they ever want to do is things like this. They learn programming, and while learning it, they want to pay homage to something they love, like, let's say, Star Wars. So they come to me and say, hey, I designed this beautiful Star Wars game. Won't Disney be thrilled that I'm making this game that is free advertising for their new movie coming out? No, Disney doesn't want your game on the market. And there's that conversation immediately goes to, okay, well, then I just won't charge for it, and it'll be fair use. Every developer ever thinks that. What's very important to know is, first off, that the monetary gain from it, the commercial use, is one factor of many in fair use, and probably completely irrelevant when you're looking at something like Star Wars. More importantly, fair use is an affirmative defense. I know there's lawyers in the room, but what that means is Disney's going to sue you, and then 6 figures later, you might prove that it's okay to sell your game that's going to fail in the App Store. So don't do it. There is no fair use for indies. There is no fair use for mid-level developers. It literally is a term that does not exist in that world. And I spend a lot of time every week explaining that to people. It's a very nice thing to learn in law school. It's something that Greg and Patrick's clients may be able to hammer home. No one I represent and no one that calls me would ever be able to do a fair use defense. It's just not within the world of the developer right now.
And the other thing they like, which is just it's a synonym for I don't have the money for, or I don't want to seek a license, is parody. Just purge those things from your mind and chastise yourself a little bit, because your job is to come up with new good ideas.
And getting back to the question about multiple studios or multiple properties, I'm in the middle of negotiating a deal now with one studio for 5 of its television properties to be in one game. And let me tell you, it is a nightmare, because now you have 5 sets of approvals. Each one of them wants 30-day window to seek those approvals for every set, every milestone, every build of the game. The game could theoretically take 8 years to make now at this point.
When I saw that Steven Spielberg is directing Ready Player One,
yeah.
I mean, I just had horrible thoughts. I mean, the idea of someone actually licensing all those things in a film, which you don't necessarily have to just write about them and describe them in a book, but you probably do in a film. It's going to be a harsh.
It's going to be a nightmare. Yeah.
It's going to be a hard. In fact, I think hubris and institutional inertia may prevent that film from being made, because it may actually be impossible to get all those egos into one movie.
Yeah, they don't have to be right to sue you. Anyone can sue you for anything, and unless you're going to defend yourself, you're going to get most likely a default judgment against you. So
if they sue you, you've already lost.
Right. I mean,
as an indie.
And exactly, the indies cannot afford to fight themselves. It's the cease and desist alone are usually enough to destroy an indie studio. Most commonly right now, I see the casino companies coming around with trademark cease and desist, because trademarks are broken up into class of goods. Video games are in the same class of goods as slot machines. There's about 1 billion slot machine trademarks for all the different things, from Enchanted Forest to Magical Dwarf, pull the lever and win an elf. I don't know. But every game coming out has a name that is already probably a slot machine. And you have companies, WMS and Valley and et cetera, sending out cease and desist that say something along the lines of, stop using the game immediately and pay us $45,000, or sign this consent judgment and pay us $200. So now they have everyone, of course, takes that $200 option, because they're going to lose their house otherwise, because, again, they don't usually consult with an attorney until it's too late, so there's no corporate structure set up. And they say, okay, here's the $200, I'll sign whatever you want. And now there's all this precedent saying slot machines are the same as video games. It's complete infringement in the trademark space, and it's creating so much bad law because indies just don't hear legal common sense, and they're doing it to themselves, really, but they're also hurting the industry at large incredibly every single day.
Because, to be very clear, it shouldn't be the same class of goods.
Right.
It is.
Okay, we have 2.5 minutes to do trademarks and 2.5 minutes to do the right of publicity. So, real quick, do I have any Lanham Act issues here that I need to think about? Well, I do.
Yeah.
So I've used a trademark, which I actually determined is still a live one. I also have two individuals here. The estate of Orson Welles, that might be a false endorsement claim, and Claire Danes might make a false endorsement claim against me. Also, the argument being that because they appear in the game, there'll be confusion about whether the game is approved by the estate of Orson Welles or by Claire Danes. And then, of course, RKO Pictures, their logo's in there, and that claim will look the same way. So, interesting developments there to mention.
And it's possible that Claire Danes, the movie studio, owns the rights to that still if you're only using still. Anyway,
We don't want to talk about preemption because we only have 2.5 minutes.
Yeah, I mean, I haven't shut up, so when you guys want to...
Well, I was going to say, one thing to ask yourself when you're doing a game like this is why do you want to use somebody else's trademark? Because there's been cases recently where the mere incorporation of somebody else's trademark into your own video game is not necessarily illegal or wrong. It's only when you do it, to suggest endorsement or to imply there's some brand affiliation, or you're trying to pass yourself off as the other company.
I was going to say, one of the craziest things I ever heard on this that is probably right. A friend of mine that works for a lot of large publishers, we were talking about driving down a street, for instance, and using a trademark or two trademarks on the road. She said, I would like this if you had more. And she said, because to the extent that it reflects reality and to the extent that there's more marks, the less likely it is for any consumer to be confused and think that all of those are sponsors.
Right. And we actually represent a client that takes a similar position. If anyone has played the game, World of Tanks or World of Warplanes by Wargaming, their whole purpose is authenticity of historic, tanks and airplanes. And so they have airplanes that are modeled directly after, fighter jets from World War II and tanks from World War I forward, and they call them by the name of the manufacturer and the model of the tank because they are trying to reproduce reality.
When I sat through one of these panels in LA a few months ago where it was people from the TV and movie studios, they feel pretty comfortable with the argument that they can have a trademark in the background of some film. Is the video game industry likely to be a lot more nervous about this? We have had some favorable cases. The Mil-Spec case is a favorable case. The Brown case is a favorable case.
Yeah, if it's incidental, I mean, that's the 3-second answer, I guess, if we're...
Not in Brown. Maybe.
Yeah.
He's not there, but...
Historically, this came about from racing games. If you look back to Atari and other games, they licensed the cars to begin with, and that made licensors hungry for licensing. And in the 2000s, I did deals where the video game paid to have branded content in the game, there was a free license for content in the game, and where the licensed content paid to be in the game. Okay? So, with all due respect to the legal academia here, I almost don't care what the law is. It tells me that in practice it is crazy when you're doing all three of those deals in a 1 year period. Now it's either free or paid to be in the game. 99 times out of 100. I mean that's how it's working. And it sounds like World of Tanks is free. I mean other places have brand integration.
And that's what's important with all this. I mean the case law is what it is, but 99 times out of 100, it's not going to get to a decision in a courtroom. So it's really just negotiating a contract deal and what the industry norm is at that point. And right now, using trademark brands in games honestly depends on how big your studio is. If you're a AAA studio, they're going to almost pay. I mean, I know Madden has live billboards in Madden where they're updated if you're on Xbox Live. And people pay to be on those billboards. It's not EA licensing out those billboards. It's for vice versa.
One other thing to think about if you're a small or mid-sized developer, remember the 5 things. You have to be doing something wrong. They have to know. They have to be pissed off. Think about how you're using that mark.
Right.
If you're using the mark in a passive background way, it's a whole lot less likely to reach 3 and 4 than if, you're urinating on it. Right?
And to reiterate, that's not parody. Urinating on a mark.
It's not fair use. Right.
All right, well, the final issue before we do Q&A is the right of publicity, or what is called in some states like New York, a right of privacy. The claim here is a state law claim as opposed to the previous ones we were talking about. The claim would be that I'm violating the right of publicity of Orson Welles by incorporating him into this product. Ditto for Claire Danes. This issue is one that's been heavily litigated recently. There's an en banc petition pending in the Ninth Circuit over the Davis case, one involving the use of retired NFL players in the Madden series. Something interesting could come of that. But the traditional rule is that games get treated in the same way as posters, T-shirts, and coffee mugs, which means if you want somebody's face or name or likeness in a game, get a license. That's not the rule for film and TV and newspapers, but games got put in this other category. The Brown decision, relevant to the last panel, seems to say games get treated in the same way as movies, books, and TV shows, but that's not necessarily how it works out in practice. Here, real quick, is the 1-minute clip that I think explains why there has been a problem.
In other words, the video game is more of an expressive work than a greeting card or a T-shirt.
A video game is per se an expressive work, Your
What
Honor.
does that mean, per se?
You can have a T-shirt, for example. The one I'm wearing under my shirt today, Your Honor, has no content on it, no expression. It's not an expressive work. The court, however...
But a greeting card.
A greeting card can be you can have a plain greeting card that has no message.
Well, I know, but 99% of greeting cards, it seems to me, have pictures and they have writing, and they're at least as expressive as a video game, probably more so.
Okay, we'll stop right there. From the judge's perspective, your average greeting card that might have one sentence is likely more expressive than your typical video game. And that comes from the oral argument last September in the Davis case. This is the one where there's a pending en banc. The case was decided by the panel in January, and a petition for rehearing has been filed.
Isn't she right, though?
Shall we take Q&A at this point, or do you want to add something on the right publicity issue?
How can you add?
You're right.
Well, I mean, as the gentleman before asked, I mean, aren't we just waiting for the baby boomers to die then so the law can catch up?
Well, let's have 2 questions. Well, you go ahead, and then you can take number 2. No, you can be number 1, and you can be number 2.
Okay, great. Hi, I had a little bit of a question about like virtual goods, and if there's been any recent things about that. I know in 2011, the gray market for virtual goods was over $6 billion, and I know that there's been some stuff that happened a while ago with World of Warcraft Gold and gold farmers and all that, and I was wondering if there's been anything more recent.
I'd love to answer that, and then my colleagues can certainly add. I have written hundreds of pages about this, including a very embarrassing ABA article in 2005 about how to kill your wife and pay for it in virtual currency. It was great. It was, it's what you want to have on your resume. So that was a problem that, like so many problems, we had hoped would be solved legally, but then was solved practically. So what I mean by that is when I was a very young attorney in 2003 and 2004, IGE was the hot issue, and it was EverQuest. I mean, it was like in Lineage, and that was, the gray or black market. And we were wondering about enforcing and how we'd enforce terms of service against these folks. Now, that case never came about. All the major publishers that I talked to flirted with that case, and we all wanted it to come about. In practice, it was solved by just terminating those people's accounts to the extent you found them farming. Now, the way, and this, maybe you haven't connected these things, or maybe you have, but the way that it was solved was the integration of goods into the games themselves. If you search for me in 2006 or 2007, you'll see me giving talks at like Austin GDC saying, I really think that it's not only legally permissible, but it would be a good business idea for us to have free-to-play games in the United States. I mean, which is hilarious right now, but I was advocating that at that time, and part of the reason I was advocating it at the time was because of the legal ambiguity around the gray market elements for virtual goods. So in my mind, that has now been entirely practically solved. We will never have that case in 2 ways. One, we just terminate the people when we find it. We don't fight about whether or not the terms of use apply to them if the parent company never clicked on the terms of use. And 2, companies that care, which essentially almost all companies are integrated virtual goods model directly into the game, and gray market can't compete when you have an internalized market. And this is even the case for console games and PC games. It's very hard to find, something that's entirely, purely no virtual goods. I mean, you should even consider DLC a virtual good, paid DLC in my mind. So I don't think we're going to get a Supreme Court case on gray market. I think the market has moved past that.
Yeah, I mean, no way to top that. So.
Thank you.
Yeah.
I was wondering whether anyone knew of any other of these game mechanic copyright cases. There's actually have a decision. We have the Tetris, the Da Vinci, the Bang case, and there was also one from 2012, Spry Fox versus LOL Apps. Do you know of any others?
There are others. Send me an email.
Okay.
Yeah, I mean, and so something like Tetris also is important because if that case came about now, or if they tried to get that protection now, there's a 0% chance they would get that. Tetris is kind of, I mean, nothing zero in law, but I'll say 1%. Tetris kind of got in before anyone at the USPTO was figuring out anything, and before a judge could open an email, let alone figure out a video game decision. So I think that look and feel protection at Tetris that they are very litigious about, or at least send a lot of cease and desist out over, is just it's not the norm in the industry.
And if you read any of the Farmville cases, the copyright infringement side, all of those demand letters, or certainly all the complaints, and most of them just ended with demand letters because the other guys rolled over. All of them talk about all of the elements that were copied, including the mechanic, right? And whether it's protectable or not, they didn't care. They were just bludgeoning people. So.
And if you send a takedown to Apple or one of the other Play stores, which is the way, pretty much your only option for a lot of people. If you complain about the mechanic, they will send you back your complaint and say mechanics are not protectable verbatim. They don't put a star and an asterisk next to it. They say mechanics are not protectable. Stop wasting our time, and that's it. And so that's a very different opinion than a lot of attorneys might tell you. It's one I happen to usually agree with and advise my clients on, but it's certainly how Apple and Google and places like that look at it.
Right. I know a lot of the demand letters I've read about out there. Are there any actual court cases, citable precedent kind of thing along those lines?
Most of those settled.
Yeah, I mean,
Spry Fox, I think, is the most recent one that had any case law come out of it.
A good complaint to read though is the EA versus
Zynga? Yeah, I know that one.
Yeah, that was just a great case that I wish was decided, but they settled before anything major.
Okay. One final point before we end. On this list, because I said I wanted to do in-game advertising, is a reference to the Federal Trade Commission.com disclosures. Can someone explain why you might want to look at that?
20 seconds on that. There's been one case that's come out, and we are currently involved in private investigations of at least 2 others that I can't discuss, and some of those will be made public by State Attorney General and Federal Trade Commissions. The bottom line is on that, to the extent you use influencers, bloggers, tweeters, viners, Instagrammers to promote your game, and they're compensated in any way, virtual currency, free play time, whatever, they have to disclose the material relationship with your company. And they have to disclose it within the media that they write in. That the only modest exception to that is if you give it to a professional game reviewer. GameSpot doesn't have to say we were giving this game for free. But if you give it to a daddy blog or a mommy blog, they've got to say. And to the extent that you have a large program and you are found out by your State Attorney General or the Federal Trade Commission, there are going to be consequences and repercussions.
How do you do that in a 6-second Vine or 140-character tweet?
In that, #ad works. And I know it sucks. And you want it to look organic. The Federal Trade Commission says that's an unfair and deceptive trade practice. The Federal Trade Commission also says if you can't do the disclosure, you should not use the media. And what you just described was the most common question I get. 6-second Vines, we often use like an end card or something like that. So just be mindful, and I'm happy to answer questions about it going forward. And it's really one of those things that's percolating. It's going to be a very big deal, but it's going to be in the next 18 to 24 months that we see the cases.
And on the ad side, again, apart from the regulatory side, you're going to have a contractual agreement with an ad servicing company that's going to put your ads into your game because you're not going to be doing it, and you're also going to be dealing with approvals on all those ads from all the various licenses you're going to get here. So advertising is going to be pretty complicated in this particular scenario.
All right. Well, thanks to our panel.